Greetings, everyone. Thank you for joining us for today's webinar, AccuSourceHR's 2022 Year-End Compliance Webinar. My name is Danielle Olivier, Business Development Manager at AccuSourceHR, and I will be your moderator today. I'd like to take this opportunity to introduce today's presenter, Jennifer Damon, Director of Compliance and Chief Privacy Officer at AccuSourceHR. Jennifer graduated from the University of Akron School of Law with a Director of Law degree and has over 10 years experience in the background screening industry. She is an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, including interpretation of criminal and civil record summaries, managing quality control, and managing the E-Verify program, including audits for a billion-dollar facility service company. She has experience with government clearances and contract review. Jennifer is responsible for AccuSourceHR's compliance department, including federal, state, and local legislation changes and industry accreditation. Additionally, she oversees the quality assurance process. Now I will turn the presentation over to Jennifer.
Good morning, or good afternoon, again, depending where you're located. Welcome to the Year-End Compliance webinar. We'll be discussing a variety of topics today, and I will be answering questions at the end of the presentation. Please send any questions you have, and I will address as many of them as possible, or will follow up through email if we run out of time. I cannot believe that the new year is just around the corner, but I really shouldn't be surprised, since 2022 was such a busy year for compliance. Let's take a look back at the past year, focusing on Ban the Box and Fair Chance Act legislation, salary transparency, marijuana and related developments, new privacy laws passed in 2022, and important industry updates. We will finish up by discussing changes and trends that we anticipate going into 2023. We will also share best practices to ensure your background and drug screening programs are compliant. As usual, before I begin my presentation, keep in mind that this webinar is informational only. Even though I am an attorney, I am not giving legal advice. We recommend that you seek the advice of qualified counsel, preferably specializing in employment law, prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. Our first topic is fair chance legislation, also known as Ban the Box laws. Ban the Box laws prohibit employers from asking about criminal convictions before a certain point in the hiring process, generally before a conditional job offer is made or before an interview is conducted. The goal of fair chance laws is to allow applicants with prior convictions to not only obtain an interview, but also advance to a certain stage in the hiring process before being asked about prior criminal history. These laws may also require that the background check process start later. A majority of the US population is impacted by Ban the Box laws, and with each webinar, more jurisdictions are added to the Ban the Box list. These laws can affect private employers, public, or both. Let's start a discussion of fair chance legislation by reviewing the most recent amendment in Atlanta, Georgia. ELMS number 30994 amended the City of Atlanta Anti-Discrimination Ordinance, and it became effective immediately upon its passage. It provides protection on the basis of criminal history status, namely by making it generally unlawful to discriminate based on the criminal history of applicants and employees. An employer is permitted to take adverse action if the criminal history is related to the position's responsibilities. This requires an individual assessment where the employer must balance 4 factors, including whether the person committed the offense. For example, was the person actually convicted, or is it only an arrest at this point? The employer should also consider the nature and gravity of the offense, the amount of time that has passed since the offense occurred, and the nature of the job. Employers also can still follow state and federal laws that may require a bar to employment for certain positions. Currently, applicants and employees who allege discrimination can file complaints with the Atlanta Human Relations Commission, but there could soon be a focus by administrative agencies and the plaintiff's bar, which in background screening should not be surprising at all. Related to ban-the-box laws are laws that provide second chances to those with criminal records, such as clean slate and expungement laws. In May, Colorado enacted a clean slate law, which creates an automatic sealing process for older criminal records if the person remains crime-free for a certain period of time. The law specifies the types of offenses and time frame in which they are eligible to be sealed. Arrest records that do not result in a conviction can be automatically sealed. Automatic sealing also includes civil infractions with 4 years since the final disposition, petty offense or misdemeanor records with 7 years since the final disposition, and felonies with 10 years since the final disposition or release from jail. There are exceptions for crimes that are not eligible, including crimes involving violence. A record also cannot be sealed if the defendant still owes restitution, fines, or court fees. The automatic sealing process starts in 2024. California recently passed SB 731, which creates a record sealing process for criminal records. Effective as of July 1st, 2023, convictions and arrests will be automatically sealed if certain conditions are met. The defendant must have completed all terms of incarceration, probation, mandatory supervision, post-release community supervision, and/or parole. The defendant must also have gone an additional 4 years without being convicted of a new felony offense. Records of arrests that do not result in convictions will also be sealed. There are exclusions. The law does not apply to registered sex offenders or those who are convicted of violent or serious felonies, such as murder or attempted murder, manslaughter, kidnapping, rape, assault with a deadly weapon, robbery, and similar offenses. While those with violent serious felonies will not have their records automatically sealed, for the first time, they can petition the court to have their records sealed. Connecticut's clean slate law goes into effect on January 1st, 2023, so mere weeks from now, and it applies to both public and private employers in Connecticut. Applicants and employees already enjoyed some protections under existing Connecticut law, where employers cannot seek information regarding criminal history that was erased, including youthful status. The Clean Slate Law has updated the definition of erased criminal history record information to now include any erased records, information relating to those granted youthful offender status, and also continuances of a criminal case that is more than 13 months old. Employers also cannot deny employment to applicants or discriminate for prior convictions for which the individual has received a provisional pardon or certificate of rehabilitation. Employers also must provide a specific notice to applicants on job applications that notify them that they do not have to disclose erased criminal history record information. We've been talking for years about whether the federal government would legalize marijuana at the federal level. While it is still illegal federally, at least as of this point, President Biden in October announced a 3-step program for federal cannabis policy reform, which was effective immediately upon its issuance. Under Step 1, the president will pardon all federal offenders convicted of simple marijuana possession. The pardoned individual must seek a certificate of pardon from the Office of the Pardon Attorney. Once the certificate is obtained, he or she must update his or her criminal records through the FBI's Criminal Justice Information Services Division. Under Step 2 of the federal cannabis policy reform, President Biden encouraged state governors to take similar steps at the state level and pardon state simple marijuana possession charges. Finally, under Step 3, the President directed the Department of Health and Human Services and the Attorney General to review cannabis's current status as a Schedule I controlled substance under the Federal Controlled Substances Act. As AccuSourceHR learns more helpful information about the pardon process, especially its impact on background screening, we will let you know. We will now shift our focus to salary transparency and related topics. In June, we discussed that the New York City Council approved a bill that amended the New York City human rights law. The goal of that amendment is to achieve pay equity, and employers were required to come into compliance by November 1st, 2022. It is now an unlawful discriminatory practice for covered employers to advertise for a job without identifying the minimum and maximum salary for that position. The amended law applies to employers who have 4 or more people, including independent contractors or employment agencies. The location of the employer does not matter if it has at least 1 employee working in New York City. While the law lists salary ranges, it does apply to both hourly and salaried positions. The range cannot be open-ended, such as $15 per hour and up, but the minimum and maximum amount can be the same, such as a straight $20 per hour. The salary range can be based on what the employer believes, in good faith, that it would pay at the time of the advertisement. Not only does the law apply to external advertisements, it also applies to a company's internal job postings and opportunities for promotion or transfer. Positions that cannot or will not be performed, at least in part, in New York City or its 5 boroughs are excluded. However, the law does apply to fully remote positions that could be performed by someone living in New York City. Temporary help firms are excluded, but are already required to provide wage ranges under another New York law. In the mid-year webinar, we covered penalties that non-compliant employers can face, so we'll not be revisiting those today. Two other jurisdictions in New York State have followed in the footsteps of New York City and its pay transparency law. Let's start with the city of Ithaca. Ordinance 2022-03 was enacted by the Ithaca Common Council on May 4th, 2022, and became effective on September 1st of this year. It affects employers in Ithaca who have 4 or more employees. More specifically, it applies to all positions for which the standard work location will be in Ithaca. Covered employers must post the minimum and maximum hourly or salary compensation in any job posting or advertisement. This includes not only new hire roles, but also promotions and transfers. The salary ranges can be based on an employer's good faith expectation for compensation. Failure to comply with the ordinance is an unlawful discriminatory practice. Westchester County in New York State has also passed a law requiring the disclosure of salary ranges. Local Law Intro number 119-2022, which became effective on November 6th of this year, amended the Westchester County human rights law. Like Ithaca, it applies to employers with 4 or more employees. Job postings, including promotions and transfers, must include salary ranges for roles that can be performed in whole or in part in Westchester County. The ranges must be based on the employer's good faith belief. Failure to comply with the amended law can result in a variety of penalties, including civil penalties of up to $250,000 for willful violations. Yes, $250,000. Washington State has also passed a salary range disclosure law in order to promote transparency and to close gender pay gaps. In March, Washington's government signed SB 5761, which becomes effective on January 1st, 2023. The law requires Washington employers with 15 or more employees to affirmatively disclose in all job postings a wage range. Employers must also include all benefits and other compensation being offered, which makes it a little bit different from some of the other ones we were just discussing. The law applies to all positions, including exempt positions. Under the law, postings refers to any solicitation meant to recruit job applicants for a specific available position. This includes recruitment conducted directly by the employer or indirectly through a third party. It applies to postings made electronically or in printed hard copy. Additionally, an employer must provide a wage or salary range to an existing employee who requests it in relation to an internal transfer or promotion. Employers who violate the law can be sued. Courts can award damages of at least $5,000 or actual damages, whichever is greater. An applicant or employee can also file a civil complaint, subjecting an employer to a civil penalty of at least $500 or actual damages. Mississippi's pay equity law under HB 770 became effective on July 1st. The Mississippi Equal Pay for Equal Work Act prohibits employers from paying an employee a wage at a rate that is less than that at which an employee of the opposite sex is paid for equal work, taking into consideration equal skill, education, effort, and responsibility. It also must be performed under similar working conditions. The Act exempts pay differences based on a seniority system, a merit system, a system that measures earnings by quantity or quality of production, and any other factor other than sex. An employer is expressly permitted to rely on an employee's salary history, the continuity of an employee's employment, market competition for an employee's services, and employee attempts to negotiate wages. The Act does not prohibit employers from asking about salary history, and it does not require pay transparency. California also joined other jurisdictions seeking pay transparency when it passed SB 1162, which is effective on January 1st, 2023. Employers have a set of obligations they must meet under the law. Employers with 15 or more employees must include the pay scale for a position in any internal or external job posting. All employers, no matter what the size, must provide a pay scale for current employee's position at that employee's request. If using a third party to announce, post, or publish job postings to applicants, an employer must provide pay scale data to the third party. It is helpful to note that pay scale means the salary or hourly wage range an employer reasonably expects to pay for a position. Under the law, employers must retain records of each employee's job title and wage rate history during that employee's employment and for 3 years after the end of employment. New pay data reporting requirements have also been added, and employers must comply with the updated reporting starting with the May 10, 2023 reporting deadline. Non-compliance can bring hefty civil penalties of $100 to $10,000 per violation. We will finish up our salary transparency discussion by reviewing Rhode Island's pay equity law. H5261A, also referenced as S0270A, was initially passed in 2021, but goes into effect on January 1st, 2023. Impacting all employers, the law seeks to create pay equity in a variety of ways. First, a salary history ban applies. Employers cannot seek pay history and cannot rely on pay history when considering an applicant for employment or to determine pay. Employers are allowed to confirm and rely on pay history after an employment offer is made in order to support a higher wage than initially offered. Upon the request of an applicant or employee, the employer must provide a wage range for that position. Differences in wages can be permitted as long as they are not based on protected characteristics. For example, wage differentials may be appropriate if they are based on seniority or merit systems, or systems that measure earnings based on quantity or quality of production. Geographic locations that impact the cost of living can also be a valid reason for differences in wages, as well as difference in shifts. Employers can also legally consider education, training, and experience, as well as work-related travel. The law also allows an employer to consider any other bona fide factor in determining wages. Rhode Island employers also must meet notice requirements as part of the pay equity law. An employer must post in a conspicuous place a notice that outlines excerpts of the law, which also explains the law to employees. An employer who fails to comply with the notice requirement faces a fine of $100 to $500. There are also a variety of penalties that a non-compliant employer may face, including civil penalties of $1,000 to $5,000. In our mid-year compliance webinar, we discussed new privacy laws passed this year in Utah and Connecticut. Because nothing has changed with these laws since we discussed them in June, I will provide a very brief overview as a reminder. The Utah Consumer Privacy Act, or UCPA, becomes effective on December 31st, 2023, and it draws heavily from Virginia's privacy law and is more business-friendly than some of the other state privacy laws. It applies to entities who conduct business in Utah or produce products or services targeted to Utah residents. A company must also have $25 million in annual revenue or more. Additionally, during a calendar year, the entity must have either controlled or processed the personal data of at least 100,000 consumers, or derived over 50% of its gross revenue from the sale of personal data, and controls or processes the personal data of 25,000 or more consumers. Even if a company meets the thresholds just discussed, there are a variety of exceptions. Because we went over these in detail in June, I will not revisit them now. However, as you can see, there are exclusions based on how consumer and sale are defined under the law. The UCPA also includes entity level and data level exemptions. Especially notable here are the data level exemptions, which exempts data that is subject to a variety of laws, including the Fair Credit Reporting Act and Driver's Privacy Protection Act. Finally, data that is processed or maintained in the course of employment, including job applicant data, is also exempt. Since we covered the UCPA in more detail in the mid-year webinar, I will not discuss this topic specifically, But keep in mind that consumers do have rights under the UCPA, such as access, deletion, data portability, and opting out. Additionally, the UCPA also outlines the obligations of data controllers, including transparency, which is generally established through a privacy notice, consent to process children's personal data, and security and non-discrimination obligations. The UCPA also establishes requirements for responding to consumer requests, as well as meeting data processing contract obligations. I will also provide a quick refresher on Connecticut's An Act Concerning Personal Data Privacy and Online Monitoring, which becomes effective on July 1st, 2023. The law applies to entities who conduct business in Connecticut or produce products or services targeted to Connecticut residents. Additionally, during the preceding calendar year, the entity must have either controlled or processed the personal data of at least 100,000 consumers, or controlled or processed the personal data of at least 25,000 consumers and derived over 25% of its gross revenue from the sale of personal data. The 100,000 consumer threshold excludes data controlled or processed solely for the purpose of completing payment transactions. The law does not include a revenue threshold, meaning that larger companies could be exempt from this law. Similar to the Utah privacy law we just reviewed, Connecticut also has some exclusions based on how consumer and sale are identified and defined. There is a difference in the definition of sale, where a sale in Connecticut also includes an exchange of data for other valuable consideration in addition to money, whereas with Utah, it only included exchange of data for money. Otherwise, the definitions of consumer and sale are pretty similar between Utah and Connecticut. As with Utah, there are exempt entities and exempt data. The exempt entities listed are similar to those under Utah, so I'm not going to revisit them currently. Connecticut lists 16 categories of data that is exempt from the law, including data processed pursuant to the Fair Credit Reporting Act and DPPA. It also exempts specific employee and job applicant data. Since we discussed consumer rights in the mid-year webinar, I'm not going to go into detail about the specific consumer rights, but again, keep in mind that under Connecticut's privacy law, consumers do have rights, including the right to access, correction, deletion, data portability, and opt-out. As with other privacy laws, controllers have various obligations as we have listed out here. The obligations include limits on the collection and use of personal data, as well as the security of data. Consent is also crucial, especially for the processing of sensitive data and the protection of children's privacy. Non-discrimination and transparency are also stressed in the law. It also outlines requirements for responding to consumer requests and ensuring the use of data processing contracts. Finally, a controller may also be required to conduct and document a data protection assessment for processing that presents a heightened risk of harm to consumers. As other states and possibly the federal government enact privacy laws, AccuSourceHR will keep you updated. We will now review recent marijuana updates. Cannabis continues to be a hot topic for the background screening industry and employers. And during this next section, we will review new marijuana protections, newly legalized medical and recreational marijuana, and other related topics. This past July, the District of Columbia signed into law the Cannabis Employment Protections Amendments Act of 2022. As you can see on the slide, the effective date is currently listed as to be determined. This is due to the law currently being unfunded, which means that there is no applicability or effective date at this time, but it may go into effect by July 13, 2023, depending on whether funding is approved or not. The law defines employer as any person who, for compensation, employs an individual, except for the employer's parent, spouse, or children engaged in work in or about the employer's household, and any person acting in the interest of that employer directly or indirectly. It also includes public employers, including the District of Columbia government. However, the law does exclude the district's court system as well as the federal government. Under the new law, covered employers cannot take adverse employment action against a protected individual. This includes refusing to hire, firing, suspending, failing to promote, demoting, or otherwise penalizing that individual based on his or her marijuana use, status as a medical marijuana program patient, or due to the presence of marijuana in a drug test, except where additional factors indicate that the individual is impaired by marijuana at that time. The law goes further and states that an employer must treat the use of medical marijuana to treat a disability in the same manner that it would treat the legal use of a prescribed controlled substance. DC employers are permitted to perform certain types of drug testing. Post-accident or reasonable suspicion drug testing is permitted, as is drug testing of employees in safety-sensitive positions. Existing district law already places limitations on pre-employment drug testing. Such testing must take place only after a conditional offer of employment is extended. The law is silent as to whether random or return to work testing is permitted, but hopefully at some point the district will provide some guidance on that type of drug testing as well. Employers are allowed to take adverse action in certain situations. First, they could take adverse action if an individual is in a safety-sensitive position, if the employee used, consumed, possessed, stored, delivered, transferred, displayed, transported, sold, purchased, or grew marijuana at the employee's workplace, or during his or her work hours, or if the employee is impaired due to using marijuana. An employer may also take adverse action if federal law or a federal contract or funding agreement requires adverse action related to marijuana. District employers have notice obligations under the law and must notify employees about their statutory rights, whether a position has been designated as safety sensitive, and any protocols for testing for drugs or alcohol that the employer performs. Notice must be made at certain times, including within 60 days of the law's effective date, annually thereafter, and when the employer hires a new employee. Before the notice requirement is effective, the DC Office of Human Rights will publish a template of the required notice. Employers can face pricey administrative penalties for noncompliance. Based on the employer's size, fines can range from $1,000 to $5,000. Repeat violations can lead to double that amount of fines, and employers could be on the hook for payment of lost wages and attorney's fees. A party alleging a violation of the law may choose to forego the administrative penalty route and instead choose to sue under a private right of action. A successful lawsuit by a plaintiff can result in an award of compensatory damages and attorney's fees and costs, among other appropriate relief. As mentioned earlier, the DC law is not yet in effect, but we will let you know as soon as an effective date is known. California employees are gaining marijuana-related workplace protections. The governor recently signed into law AB 2188, which amends the California Fair Employment and Housing Act. The amendment is not effective until January 1st, 2024. Some employers have about a year to come into compliance. The updated law prohibits employers from discriminating against a person in hiring, termination, or any term or condition of employment based on the person's use of cannabis off the job and away from the workplace. The law also specifies restrictions in drug testing for marijuana. When the law goes into effect, it will be unlawful to discriminate against an individual based on an employer-required drug test that detects the presence of non-psychoactive cannabis metabolites. In other words, an employer cannot rely on a positive cannabis drug test result if the test screened for non-psychoactive cannabis metabolites. This essentially means that currently available workplace drug tests are going to be a no-go, since they typically test for non-psychoactive cannabis metabolites. Because of this testing restriction, employers should be prepared to remove marijuana from pre-employment drug screening panels and should also revise their policies to only take adverse employment action against employees who are caught possessing, using, or being impaired by drug use while on duty, whether they're working their hours or at the employee work site. The law does include some limitations. Employers can still restrict marijuana use on the job. For example, employees are not permitted to possess, be impaired by, or use cannabis on the job. Employers can also maintain drug-free workplace programs. Employers are not required to waive their rights or violate any obligations under federal law or regulation. The law also excludes employees who work in building and construction trades, as well as applicants or employees who apply for or work in federal jobs that require Department of Defense clearance. The law does not go into effect for another year and will likely receive additional guidance as January 1st, 2024 draws closer. Since our last webinar, another state has legalized medical marijuana. Executive Order 2022-798 will allow Kentucky residents who are diagnosed with certain medical conditions and receiving palliative care to purchase, possess, and use medical cannabis. The order also grants a full, complete, and conditional pardon to those who are accused of possessing marijuana under Kentucky law. However, in order to receive the pardon, the accused must meet 4 conditions. First, the marijuana must have been legally purchased within the United States but outside of Kentucky. Second, the individual must show proof of that purchase. The amount cannot exceed 8 ounces. Finally, the individual must provide a written certification from a doctor proving that the individual has been diagnosed with one of 21 medical conditions that are listed out in that law. Employers can still drug test if it is in compliance with the Americans with Disabilities Act. Employers are also permitted to prohibit the illegal use of drugs and the use of alcohol at the workplace, and can also require that employees not be under the influence or illegally use drugs while at work. It's currently hazy whether an employer must reasonably accommodate an employee's use of medical marijuana outside of work, but we do hope that guidance on that piece of it will come soon. Legalized medical marijuana becomes effective in Kentucky as of January 1st, 2023. On May 24, 2022, Rhode Island became the 19th state to legalize cannabis for adult recreational use under the Rhode Island Cannabis Act. Adults who are 21 and over can now legally possess marijuana up to 1 ounce. Adults are also permitted to grow up to 6 plants for personal use, but only 3 of those plants are allowed to be mature. An adult can also possess up to 10 ounces of cannabis in his or her personal residence. The Act also automatically expunges prior civil records, misdemeanor, and felony convictions for possession of marijuana that would now be considered decriminalized under the law. All eligible records will be expunged by July 1st, 2024. How are employers impacted by the Rhode Island Cannabis Act? Employers are not required to accommodate the use or possession of marijuana or being under the influence of marijuana in any workplace or other location where work is performed. This does include remote work. Rhode Island employers can take adverse employment action based on an individual's violation of a workplace drug policy or because he or she was working while under the influence. However, employers are generally prohibited from terminating or taking other disciplinary action against an employee solely based on his or her private, lawful use of marijuana outside of work, as long as he or she was not working under the influence, of course. Positive drug tests will likely not be enough unless there was evidence of current impairment at the time of the drug test. And this is due to some of the limitations with drug testing for current marijuana impairment, which we hope is going to be resolved fairly soon. There are exceptions under the law, including if use outside of work is prohibited by a collective bargaining agreement or if the employer is a federal contractor. Employers may also be exempt if they are subject to a federal law or regulation and could lose a monetary or licensing benefit if they do not terminate or discipline the employee. If an employee works in a job that is hazardous, dangerous, or essential to public welfare and safety, an employer can prohibit the use of cannabis within the 24-hour period prior to scheduled work. Please keep in mind that the Act does expressly limit an employer's ability to rely on off-duty cannabis use in making certain employment decisions. In the 2022 midterm elections, Missouri became the 20th state to legalize marijuana for recreational purposes, specifically for individuals over the age of 21. Under Amendment 3, those over 21 can purchase and possess up to 3 ounces of marijuana. Individuals can also grow up to 6 flowering marijuana plants, 6 non-flowering marijuana plants, and 6 clones, as long as the individual is registered with the Missouri Department of Health and Senior Services for the cultivation of marijuana plants. Marijuana plants that are grown at home must be kept in a private residence, in a locked space, and not visible to the public. Note that while the law became effective on December 8th, it is likely that the earliest that recreational cannabis products will be available for purchase is after February 6, 2023. Amendment 3 also allows defendants to petition for the expungement of certain marijuana offenses. Additionally, by June 2023, all circuit courts must order the expungement of the criminal history records of all misdemeanor marijuana offenses for anyone who is no longer incarcerated. Amendment 3 not only legalized recreational marijuana, but it also amended Missouri's existing medical marijuana law by adding new employment protections. An employer cannot discriminate against or penalize an individual who has a valid medical marijuana card for having the card itself, for legally using medical marijuana off premises and outside of work hours, and for testing positive for medical marijuana. The usual types of exceptions apply. An employer is not required to lose a monetary or license-related benefit under federal law. A medical marijuana user is also not entitled to use, possess, or be under the influence of medical marijuana while working. Safety-sensitive positions are also excluded. Employers are permitted to drug test, but cannot take adverse action against an individual who possesses a valid patient ID card. Maryland also legalized recreational marijuana during the midterm elections, becoming the 21st state to do so. Question 4 and HB 837 become effective on July 1st, 2023. Sorry, I'm trying to make it a past effective date. It's actually in the future. Those who are 21 years old or older may use recreational marijuana and may possess and use up to 1.5 ounces of marijuana or 12 grams of concentrated marijuana. Individuals can grow up to 2 plants per household and can share cannabis with other adults without payment or trade. The current decriminalization of marijuana currently in place is extended until July 1st, 2023, when legalized marijuana officially goes into effect. The law also provides for the expungement of criminal offenses that are now considered legal. We do not yet know the impact on employers, as HB 837 does not address how an employer can approach legalized recreational marijuana in the workplace. If this portion of the law is clarified, we will absolutely let you know. Marijuana legalization and its impact on the workplace seems to be getting more complicated with each passing year. Employers should start by reviewing the new laws and revisiting existing ones with in-house or outside legal counsel who are able to assist in determining your rights and obligations as an employer. Secondly, it's critical to document, which will make it easier to show where your company stands on cannabis, especially if you are a multinational company. While President Biden has initiated federal marijuana reform, keep in mind that marijuana is still illegal at the federal level at this time. You may also have accommodation obligations under state disability laws. You should also work with legal counsel to determine if you are permitted to drug test and whether that testing is limited. While I could speak about several industry updates today, I'm going to provide an update on California identifier redaction. We've discussed in several webinars the impact that All of Us or None v. Hamrick has had on background screeners and employers. With date of birth and driver's license information being redacted and no longer searchable in an increasing number of California counties, it impacts our ability to report some records in California at all due to insufficient identifiers. The California legislature did pass Senate Bill SB 1262, which would have alleviated identifier access issues in California by allowing searches and filtering by driver's license number, date of birth, or both. However, on September 29th, Governor Newsom vetoed the bill, citing privacy concerns. Our industry group, the Professional Background Screening Association, and its allies are currently regrouping to determine the next best option to restore identifier access. As of today, we have not received any updates, but we will keep you informed of any updates as we receive them. What will 2023 bring to the background screening industry and employment law? Fair chance laws are broadening, and more jurisdictions are allowing the expungement and sealing of older criminal records. As states seek to address pay equity concerns, salary transparency laws will likely increase. Privacy is always an important topic, and several laws are going into effect in 2023. It would not be surprising if new laws were passed in the next year, potentially even a privacy law at the federal level, which is currently being reviewed. As marijuana is legalized and employers work through their obligations and rights under the new laws, we will examine legalization's impacts and provide recommendations to tailor your drug screening programs to be compliant. Our industry will continue to advocate against identifier redaction so that we can provide the most robust and accurate background checks possible. AccuSourceHR will continue to keep you posted of any industry trends and hot topics as we learn of them. Before we complete this presentation, we'd like to recommend some best practices. First, make sure that you review your background and drug screening procedures and hiring practices to ensure that you are compliant with any new laws. Review your employment applications and hiring practices to make sure that you're not seeking information that you cannot legally request, such as criminal history and past pay information. Watch for salary range transparency requirements and come into compliance if they apply to you. Review new privacy laws closely and determine if you need to come into compliance. Be aware of newly legalized marijuana to determine its impacts on your policies and drug testing programs. We recommend reviewing any of these areas with your in-house counsel or outside counsel to determine how the changes affect your background and drug screening programs. We've reached the end of the presentation, and I will now answer questions that we received.
Thank you, Jennifer. So the first question that we have is surrounded by the first section of pay equity. So for pay transparency, if the company is California based, but we have employees in Washington and Colorado, do those rules for Washington and Colorado still need to be in play, even though the company is California based?
So if you do have, it applies when you have a certain number of employees within that jurisdiction typically. And I have to go back and look at the laws more specifically because they do differ slightly. It's never just a cookie cutter fit that's easy to determine and provide an answer right off the top of my head. But yeah, even though you're based in California, it does take into consideration where the employees are. It's about what's fair to them. So if anything, what I'll do is I will take a look at your question afterwards and try to provide a more targeted answer since even though I've been working on this webinar, I don't have the laws memorized currently and want to provide the best answer possible.
Fantastic. Another one in regards to pay equity, when we're talking about states requiring pay ranges, if you have at least 5 employees or at least 15 employees or whatever the number, does that mean an employee with at least 5 or 15 people working in that specific state, or companies that have 15 or more employees in total?
It's going to depend on the specific law, but off the top of my head, it generally appears to be that number of employees anywhere, not necessarily limited. So for example, in New York City, it's 4 employees or more total with at least one who's working in New York City. So each law could be different, but it's likely going to be based on that total number of employees, no matter where they're located. So it's probably going to be pretty broadly applicable to a lot of employers.
All right. We have one scheduled around marijuana and drug screening. The
Okay.
question, we are a DC employer and don't drug test. Do we still need to issue our protocol for testing for drugs?
To be on the safe side, I would probably consider providing something saying that you do not drug test, whether it's in a policy and procedure manual, just so that way it's very, very clear to applicants and employees that you do not drug test. The law seems to be silent on that based on my recollection, but I'm always of the mind that it's better to document something than to not document. So that way you have the proof in case you are questioned.
Great. We're almost at the end of our time, so this will be the last final live question. You went over expungement and similar laws, especially in California and for federal simple marijuana possession charges. How can we keep better track of which records are going to be expunged?
So when it comes to the marijuana charges, especially at the federal level, It does put the onus on the individual to take certain steps to request the expungement and provide proof and receive the certificate. California is a little bit more complicated because a lot of them are going to be automatic expungements and automatic sealing. I was actually just speaking with a client about this the other day because they want to be proactive and figure out how to address this before it goes into effect, I believe July 1st of this coming year. Um, it's hard because you could base it on the type of offense and thinking that it will be sealed. But the issue is that they also have to go 4 years without being convicted of another felony. If you're a typical employer, you might screen um, past counties where a person has lived or worked, where they currently live. The issue with that is someone could have been arrested in another county. They could have been traveling or just in a neighboring county. It may not show up on their background check that they've been convicted of a felony. So you can't assume necessarily that a misdemeanor record is going to be expunged because it's been beyond 4 years. So at this point, we really do have to wait for some guidance from the regulators because it's a little bit murky just because of the way background screening works today.
Fantastic. Thank you, Jennifer, for facilitating this informative webinar, and a special thank you to our attendees for joining us today. If you have any additional questions, please contact us at marketing@AccuSourceHR.com. On behalf of the AccuSource HR team, we wish you all a wonderful day.